But just to give you some idea to what I'm going to be speaking about, of how Indigenous peoples are no longer dependent upon the dominant society that has come into their territories and created a nation state over the top. In most cases around the world, the evidence reveals that Indigenous peoples are, in these up to 80 different countries, are the most marginalised populations that are deprived of political representation and power, suffer from significant developments on their territories without their approval, etc., etc. So what we know of Australia, the Aboriginal and Torres Strait Islander people, is very, very typical. We would think that our situation is unique in the way that we have experienced it, but in fact it is, as I said, across 80 different countries, affecting up to 400 million people around the world. And it wasn't until very recently that this became a focus in the international community through the United Nations. And my talk today is going to cover across all of that in some particular order. But also my talk today has a bit of an edge. I mentioned this yesterday when we had a meeting, a teleconference and a meeting, which involved both the government representatives and important Aboriginal and Torres Strait Islander peoples, organisations and leadership to talk about this forthcoming World Conference, which is happening in September on the 22nd and 23rd. And that I mentioned to them that today I won't be so tactful or diplomatic in some of my comments. Today my Congress hat goes firmly on. As Kirsty has mentioned, at the moment I'm one of two Indigenous peoples delegates who have been appointed as advisors to the President of the General Assembly, and our role is to do all the necessary preparations which will lead up to this World Conference. It's a challenging task, but so far it's been very successful, and you have on your table some documents to which I will refer, which have just recently been released as drafts to go to that World Conference for adoption by all the states around the world. But I'll come to that as I near the fourth part of my speech. I have four parts that I'm going to talk on. Let me begin by backgrounding Australia, because my talk is going to be pointing out that for the ups and downs we've experienced in Australia, and I'm going to talk about the period in which the Commonwealth assumed responsibilities for Indigenous affairs in this country, we haven't had the outcomes to which we were entitled. So many of you know background and history on this. You have your own knowledges and perhaps even own versions and interpretations of the history. But I'll start with the point that in 1967, when the referendum was held, that was the beginning of a social contract in this country, a social contract that should involve the nation of Australia and the Aboriginal and Torres Strait Islander peoples. And I picked that particular date because it was a referendum, and because it moved responsibilities to the national government. It didn't just leave them then with the former colonies, the states and territories of Australia, which, as we know, for people who are a bit older and experienced some of that time, depending on which side of the border you're on, you are subject to different law, different treatment, policies, assistances and everything else. On one side, in New South Wales, as an example, you had a completely different arrangement about how government provided you and assisted you with services to what happened in Queensland or what happened in Victoria, etc., etc. And a big part of 1967 was to really address that. Now, before I clarify about what happened in 1967, this was a part of world history. 1967 was not an accident, and it didn't just come from nowhere. And this world history that I'm talking about is World War II and the result of World War II. And it was during World War II that the Allies, particularly led by the United States, formed the United Nations. It was a word used, coined and used through that war period. I think in 1942 it was starting to be used by the USA president, and of course was a body which formed solidly immediately after peace was declared in the battle in the Pacific against Japan. And this first United Nations body, I think, was made up, if I remember correctly, of 34 nation states around the world. And it had a distinct purpose. It was basically saying, well, this is the Second World War. We don't want a Third World War. We don't want this to keep on happening. And why are these world wars occurring? And the realization was that the wars were occurring because of imperialism, of a lack of international respect for boundaries and autonomies of states and territories. And there were various nations from Europe, I think clearly from Europe, that were colonizing the rest of the world, in Africa, in Asia and Southern Asia, in the Pacific, in South Americas, Central and South Americas. And so the movement towards the United Nations, and it's firmly entrenched in the Charter, it was about the self-determination of peoples. And when you go to the United Nations Charter, which was written there in 1945, the first thing it says is, we the peoples of the world. So it was not saying we the governments of the world are going to collect together as governments and make decisions as governments. It was basically decided that it was a collection of peoples of the world, and respecting it was the peoples who should be looking after global governance and peace, harmony and security. And very quickly the numbers of the United Nations members rapidly increased as these European powers removed themselves from the regions. Africa was a big focus on that, and as we would be able to piece together over the next 20 to 30 years, the number of independent nations that were formed rapidly increased to the point now, in 2014, I believe it is 194, it might be 196 independent states throughout the world. And some of those independent states are very, very small. Pacific nations in particular, places like Tuvalu, Nauru, and so on, would only have 12,000, 15,000 populations in it. There still is some process going on. The most recent we had was, I think, the creation of South Sudan as an independent nation, and before that East Timor, or Timor-Leste, which became independent as well. And the point there being that the whole UN Charter and the international governance system that's created by the UN is based upon this principle that peoples have the right to self-determination. Peoples have the right to autonomy and to have the rights to their lands, territories and resources, and to decide their economic, social, cultural and political futures. This is a fundamental principle. But the problem comes about when the United Nations finally decided in the 1980s, early 1980s, to examine the situation of the indigenous populations around the world. And that was a report that was ultimately presented called the Cobo Report, quite a lengthy, voluminous report, which basically pointed out where I started at, that indigenous populations around the world are marginalised, are exploited for their territories and so on. So the world had forgotten to decolonise indigenous populations. And apart from fortunate areas like in the Pacific Islands and a few other areas, this population I'm talking about, this 350 to 400 million people around the world, in all the different continents of the world except Antarctica, were still living under an oppression of a state and a dominant society. Well, of course, I'm describing Australia. And Australia, if anything, is unique in that scenario. It is unique because more than anywhere else in the world, we know we have the oldest surviving civilization, 40,000 years plus. And of course, as they do more and more technical research and study on this, that figure keeps becoming longer and longer. But it's a continuing culture and a continuing civilization. So there's been no interruption apart from the impacts of colonisation in Australia and the effects it's having on the total population of Aboriginal and Torres Strait Islander peoples. But the connection with the ancient cultures is still there and continuing. The other thing that I think is particularly significant for Aboriginal and Torres Strait Islander peoples, which I learned talking to a lot of the Indigenous delegations around the world, is the strength of our attachment and connection to country. That all Indigenous populations can be identified by their connection to their territories and their inability to trade their territories as property or for exploitation. They are all connected and rooted in their territories. But the connection here is so strong. It's strong because we have a very tangible link to the natural environment and to the geographical environment. We are part of that. We are not just people who might have, in some cases, like New Zealand, there's a movement of the 4 canoes to arrive at New Zealand and begin the civilization there with the Maori people. Well, in Australia, we don't have a migration story. We have a story of coming from the earth, how the spirit comes, how the spirit enters into a body and lives in a body, and then when the body finishes, how the spirit moves on. And it's that the depth of that and the strength of that I've found is so strong. I'm not saying it's different, but it's so much stronger and so much more entrenched in my experience in the way that Aboriginal and Torres Strait Islander people feel about their connection to country and so on. So now getting back to 1967, it was those developments from 1945, from the formation of the United Nations, its charter, which was soon followed up by the Universal Declaration on Human Rights, became a human rights standard, a universal standard, which is now, even though it's only a declaration, is now recognised as an international obligation and norm. So some of you will hear Australia and other governments from time to time say how the Declaration on the Rights of Indigenous Peoples, because it's a declaration, has no legal implications for Australia. But that's just a matter of process. Like the UDHR, the Universal Declaration has become an accepted norm and has become interpreted in domestic laws all around the world. There's no domestic legislature that I can think of that wouldn't regard the rights that are contained in the Universal Declaration on Human Rights as being an obligation upon the state, and so on. So from the point that the UDHR was negotiated and settled upon, these fundamental rights and freedoms of the individual, then the United Nations started the process of creating certain human rights treaties. And one of the first of these to roll off was the treaty called the Convention on the Elimination of All Forms of Racial Discrimination. This was, at that time, a big issue. It was a big issue because of Africa. It was not only South Africa, but it was places like in what was northern and southern Rhodesia and other parts in Africa of where there was still very much a segregation approach to the black people, the original people of the regions, as well as other parts in Asia, including in India, with the campaigns that were going on in India for autonomy, and other parts of Asia as well. So the concept of race and racism was very strongly felt at that time and led to that convention as a strong dogma to be observed around the world. At the same time, there was also the Covenant on Civil and Political Rights being developed, and there was a Covenant on Economic, Social and Cultural Rights, which was a covenant to balance the civil and political rights. It was about, well, not all rights are just civil and political, there are economic, social, cultural rights, which was a bit of a contest going on between the East and the West in relation to what rights were. Now, the two covenants on civil and political rights, Covenant on Economic, Social, Cultural Rights, and the Universal Declaration on Human Rights, for those of you who don't know, who haven't studied in this area, is now known as the International Bill of Rights. So it's basically accepted as the cornerstone of human rights around the world that should be observed. Not all countries have ratified all conventions, but if I understand it correctly, I haven't actually looked at this, but I think the Convention on the Elimination of Racial Discrimination is the one that's been most ratified of the treaties, and certainly is in there. 1966, Australia signed on to these conventions, and 1966 and 67, if I remember, and signed, but did not ratify necessarily these treaties. Now, the idea of a treaty is to make a legal commitment or a legal obligation to take actions to respect human rights. So by signing on to a treaty, a country decides or determines that it will now accept an obligation and will implement that obligation domestically. So Australia has, just to jump ahead a little bit, of all the major human rights treaties, ratified all of them. It stands out amongst all of the nations around the world as an example of a good international citizen by agreeing to all these treaties. However, not all treaties are in legal effect in Australia. I'm not a lawyer myself, I have to make that clear, but I understand because Australia is a common law country, signing on to these treaties does not immediately make those obligations in the treaties part of Australian law. Australia has to enact legislation to make them part of Australian law. Some other countries which have a different legal system, by signing on to the treaty, actually becomes part of the law of the nation, but not so Australia. So Australia has to go through two stages. One is to sign and ratify. The other one is to implement legislation to put those matters into law. There's an additional, I'll call it an obstacle, but there's additional challenge for Australia also, that once it ratifies a treaty, it has to ensure that as a federation, that is, the Constitution makes us up of a collection of states, that as a federation, that the treaty is being observed in all of the states and territories. Now that's an interesting point, because this is now, in our current situation, which I'll come to talk about, how Australia will dance around its international obligations. It will basically say, well, we're in support of that human rights, but we can't tell that government, Queensland or New South Wales or Tasmania, we can't tell that government what to do about that. And so they use, when they go back to report to these treaty bodies, they use the excuse that we're a federation, we have to respect the federation. Now, the interpretation that these treaty bodies have is, well, that's not our problem, that is your problem. Once you ratify and sign these treaties, you have to resolve that problem domestically. It's not an international problem. We have a right to see these human rights being respected and the actions being taken across all of the states and territories, and that's a problem of Australia, not a problem of other parts of the international community. And to clarify again for the people that might not know human rights law, that in most cases the treaties include in their provision of how the treaties are to be monitored and followed up, and therefore they create within the treaty itself a treaty body like the Committee on Elimination of Racial Discrimination under the Convention on the Elimination of All Forms of Racial Discrimination. So that committee then functions to monitor how states are meeting their obligations. And the way they term it is that they're there not to police states, they're there to assist states to meet their obligations. So they still are limited in terms of crossing over boundaries into domestic issues. They can't do that, but they can assist the states how to meet their obligations to do that. So as I said, most of the treaties then are monitored by treaty bodies. And these treaty bodies, also to emphasise a point, are independent and autonomous. They're not controlled by the UN system, they're not controlled by any other bodies, they are only controlled by the member states who sign onto that treaty. So if 50 states sign onto a treaty, those 50 states then get to vote on who sits on the treaty body, and those 50 states are the only ones who can then pursue an amendment of the treaty and so on. And on that last point about amendment of treaties, it is almost impossible to amend a treaty once it has been adopted. The process of negotiating and adopting a treaty to meet human rights standards is a hard and arduous one. There's a lot of argy-bargy coming from all different areas, and the final agreement to a treaty, which is as close as possible to a consensus, nobody wants to go back and reopen that package because all sorts of things could happen and problems eventuate from revisiting. So the treaties are in themselves a particular strength, and the treaty bodies in themselves are a particular source of authority in relation to human rights around the world. So let's go back to that point of the referendum in 1967. So when Australia finally held that referendum in 1967, it was merely to the timetable and in step with what was happening around the world. And not only that, but it was at a time when Australia was showing leadership in the international community, that we had an Australian an authority, actually sitting as Secretary General in the General Assembly during part of that. And so Australia was very much to the driving of these standards, of these conventions, these procedures and so on during that period. But Australia still had its own domestic politics to deal with. And as I understand, as we look now at the review of the Constitution, that in 1967, it took 4 attempts to get that referendum up. It had been rejected by the government of the day for the first 3 attempts, and it was only on the 4th attempt that the referendum was held, and as we know, had such an overwhelming support in the Australian community. So my first point that I made was that by adopting that referendum, by having that change made in the Constitution, and we all have different interpretations of what it means, like citizenship for Aboriginal and Torres Strait people, or the end of racial discrimination, or things like that. For everything else that could be an interpretation, whether wise or unwise, it was the development of a social contract. And it was the development of the Commonwealth assuming that it has the responsibility and the authority to deal with the circumstances of Aboriginal and Torres Strait people, and to deal with that as part of its international standard and representation, to comply with the Race Convention, to comply with the concept of international governance through the United Nations and so on. So having established that point of the social contract, what's happened to it since then? Well, as we know, nothing much happened for 4 or 5 years, until finally there was a change of government from Conservative government to the Whitlam government in late 1972. And immediately upon the appointment of that government, the government acted to appoint an exclusive full-time Minister for Aboriginal Affairs. So that was a first. To appoint a Department of Aboriginal Affairs, that was a first. And there were a few other things that followed on soon after that. The Racial Discrimination Act, adopted in 1975, became a significant landmark. And even though it didn't take until a year after the Whitlam government, the Northern Territory Land Rights Act of 1976 was also one of those things that happened. So these, we can argue, are all part of that social contract being fulfilled, to pay particular attention, to standardise the treatment of Aboriginal and Torres Strait Islander issues across the nation instead of state by state, to ensure that racial discrimination was prohibited and prevented, to provide land rights to Aboriginal and Torres Strait Islander people, are all part of that implementation of that social contract. Unfortunately, the land rights that was applied was only for the Northern Territory, and that had there was a particular reason for that, and I'll see if I can make that excuse for that. And the first one is that it was heavily contentious. We had the situation in the Northern Territory of people nailing up signs in their roadhouses and in their houses, and so on. Any blackfellow that steps on here is going to get shot on sight, etc., etc. A nice revisit to history in Australia 40 or 50 years ago. And so it was highly contentious and difficult even in Canberra. So it wasn't until Malcolm Fraser won government and personally took charge of that legislation, that it was successfully adopted in 1976. And the land rights legislation to this day remains one of the highest standards around the world, to this day. And these are the elements that are important about it. One is it recognised the relationship between Aboriginal people and their lands, territories and resources. The second is that it provided a process for lands to be handed back. Lands that Aboriginal and Torres Strait Islander people had lost during the colonisation and nationhood process could be claimed back, focusing very much on vacant Crown land, but also being able to include other types of land such as pastoral leases and so on. It also provided recognition for sacred sites. It provided control over mining. This was one of the elements, is that the land rights policies of that era was that Aboriginal people have the right to control mining on their territories. In fact, they used the word veto in that process. Later on, the legislation got softened to weaken that veto, to bring it more back to control. But it's still there. There still is that strong ability to prevent or prohibit or to hinder unwanted mining and development in their territories. It also included the provision for where mining did occur for the royalty equivalents, but it's the royalties that the mining industry would pay to government, to be handed to the Aboriginal people of the Northern Territory. Right. So, for those of you who know the Act, it provides for 30% of the royalties. I'm not sure if I got the figures going to the right people, but it's 30, 30 and 40. So I think it might be 40% goes to the traditional people of the area where the mine is concerned. 30% goes to the Aboriginal Benefits Trust account, as it was called then. And 30% goes to the land councils of the Northern Territory to provide structures that can manage and maintain the interests of all the Aboriginal people in the Northern Territory. So it was, and this was not just a percentage of mining royalties, this was the full equivalent of mining royalties that's happening in there. And the concept, which is different from native title, was that the benefits were for all the Aboriginal people of the Northern Territory, using that 40-30-30 model. 40 to the traditional owners, 30 to the Benefits Trust account, 30 to the Lands Council in the process. And the other thing that I'll mention here that was particular to that land rights legislation, which we don't see in native title, we don't see in other legislation, is free, prior, informed consent. So before anything can happen in relation to a particular people's territory, the Land Council has a statutory obligation to get consent from the people who have an interest in that area, a traditional interest in that area. So it doesn't allow the Land Council to make the decision, it allows the Land Council to advise that the decision has been made by the traditional owners to accept that. And that puts the Land Council in a challenging position, of course, because it means they have to round up the relevant people, they have to explain and make it clear to them what the issue is about, they've got to ensure that they are consenting, they're not just being bullied or railroaded or confused in the process, and then when it has obtained that consent, then relay that decision onto it there. So that legislation in 1976 has never ever been met or recalled in Australia by anything that's happened since then. So again, going back, this was the social contract that was developing during that period of time. Part also of the social contract was the Whitlam government's commitment to create the National Aboriginal Consultative Committee, the NACC, and it arranged through a lot of work for electoral rolls to be built up all around Australia of the Aboriginal and Torres Strait Islander people. There's a lot of money put into that by roving liaison officers and so on to build those roles, and then using those roles, election for this national body, the NACC, was held. The roles were not always complete. There were people that were not always on there, but then those people could, if they could show that they're on the, if they're a legitimate person by showing that they're on the electoral roll, if they could show that they're accepted as Aboriginal or Torres Strait Islander people by their community, could still cast their vote in that process. So again, this is the social contract we saw coming out of the 70s and so on. So what happened to the social contract? Well, there's a few things. There's one other thing in that social contract at that time that I should make point of, and that is to fund community-run organisations for needed services. So it was the Aboriginal and Torres Strait Islander people in that era who were defining what were the services needed, and the first things we saw, which originated a lot from the Sydney efforts here, Melbourne, as well as Brisbane, were things like the legal services, the housing services, because, if you were a blackfellow in those days, you had no chance of getting a house on the rental market. And of course, there was no chance of owning a house either. So housing services and the medical services, these were the three key services that had first emerged, and then they were followed up then by the great diversity of services that we now know have been established around Australia. So the concept of a community being able to define its own programs, needs and services, the community being able to deliver those programs, needs and services and so on, are all, again, part of that social contract. So when we move on in towards the 1980s, there started to be some deterioration of that. And I mention these service organisations because the Fraser government, you might have heard of the Razor Gang that went through, and of course there was a great cutting of services to Aboriginal and Torres Strait Islander people. The money's going to these, but they didn't interfere with the organisations themselves, just cut the funding as savings. This was something that went on there. There was a return back to a Labor government in 1983. And in fact, in that period in 83 onwards, for the next 10 years, was a continuing of the social contract. In the Fraser years, the NAC was revised and the National Aboriginal Congress was first mooted, and then that became the National Aboriginal Conference under the Fraser government. As soon as the Hawke government came into power in 1983, it doubled the funding to the National Aboriginal Conference to give it more capacity and power, and then started consultations on creating a national land rights legislation. I won't go into the story on that because that legislation failed to appear in 1985 because of the West Australian elections. Bob Hawke said they will not be proceeding with national land rights legislation. Now, the national land rights legislation that was being drafted, and I was on the NAC at the time. Sorry, I might just jump backwards by a year by saying the first thing they did was to create an Aboriginal Heritage Act. And so that was done in conjunction with the NAC, and that happened in 1984, called the Interim Aboriginal Heritage Act. And then the idea, that was to test the Parliament, test the mood of the community, and then move on to the national land rights legislation. So that was the first sign of a withdrawal back from the social contract, to basically the Hawke government saying, we can't do this, it's politically unpopular, so we're not going to proceed with that. Soon afterwards, the NAC was very much in a contest with the government about this. They were not happy. There were big protests in Canberra in May of 1985. There was a strong formation of a coalition of Aboriginal organisations led by Rob Riley as the chair of the NAC in those days, which caused a lot of heartache for the government and for the Department of Aboriginal Affairs. So let me mention two more things that happened, which is this building of this social contract. One was that the Hawke government decided to create the Aboriginal Development Commission. So it basically created an authority, which was a commission, which was run by a board of Aboriginal people, Aboriginal and Torres Strait Islander people, and by a CEO who was an Aboriginal person, to look at the economic development. So things like the housing loans, the land acquisition loans, and funding and so on, and other areas moved into this Aboriginal Development Commission, which became a parallel body to the Department of Aboriginal Affairs, and which was responsible for economic development. And then later on, the Department of Aboriginal Affairs was disbanded for the Aboriginal and Torres Strait Islander Commission. So the process moved to say, well, Aboriginal and Torres Strait Islander people should now be in total control of the bureaucracy, of the system of government, and it'll be under an elected leadership, the commissioners, elected by the people, from the people, and consuming the operations of the Department of Aboriginal Affairs, consuming the operations of the Aboriginal Development Commission, consuming the operations also of statutory authorities, including the IATSIS, what was called the Aboriginal and Island Studies, Australian Aboriginal Island Studies or something like that, and other authorities including to deal with land, to do with loans for housing, and so on, all came under the ambit in one way or another of this commission. So that was probably the pinnacle of the government going to meet Indigenous peoples at a point. On the way it had faltered because of the national land rights legislation. That was definitely a failure to deliver what it should have been delivered. Now, many of these things are referred to there as being part of the social contract. When you look at the Declaration on the Rights of Indigenous Peoples, are described pretty much exactly in the Declaration. Indigenous peoples have the right to run their own programs, decide their own services, have the right to free, prior and informed consent, have the right to ownership of their lands, territories, resources, etc., are all elements that are in the Declaration. So Australia, before the Declaration was adopted, a decade later, many years later, had achieved some level of authority in here. Oh, yes, there are shortcomings, and I'm sure people who were around at the time will get up and very quickly point out the shortcomings. It would be good to have Gary Foley here, of course, who will say, oh, that was nonsense and they were not really successful in doing it and so on. But I'm arguing from the viewpoint that government was moving in a direction, and it was moving in a direction that was towards where Aboriginal and Torres Strait Islander people wanted. Well, since then, we've had the Howard government, and from my point of view, I should mention one other thing, and that is the Paul Keating speech of Redfern, where he offered the social justice package as remedy, where he talked about the problems of the history past are the problems inflicted upon Aboriginal and Torres Strait Islander people by the white people, where he pledged to make compensation and remedy for those injustices, not just by the Native Title Act, by the creation of this new Indigenous Land Fund for purchase of lands, and by this social justice package at the time. So that was probably the point of where things then went south, because soon afterwards, that is 2 years afterwards, the Howard government came into play, and then within 2 years, 3 years, the Howard government had changed the Native Title Act, had weakened the ATSIC authority, had cut out, was it 450 million out of programs going to Aboriginal and Torres Strait Islander people, which knocked out a lot of our organisations that were dealing with local community support, programs aimed at the women, the children, the families, and community harmony and so on, were the areas that suffered when that $450 million was cut. So it's at that point now about the social contract package I'm going to switch to my next part, and that is that at the time of Howard, and I was actually the deputy chairperson of the National Indigenous Working Group on Native Title. This was a coalition of all the land councils, land rights bodies, and rep bodies that existed around Australia, who were fighting for the rights that came out of the Mabo decision and fighting against the changes that the Howard government wanted to inflict upon the Native Title Act. When the 98 amendments went through in the Native Title Act, it clearly became a discriminatory law, and talking to our advisors at the time, which included Ron Caston and other senior counsel, Queen's Counsel at the time, they basically said that there is it's not good sense now to legally challenge the racism of these laws in Australia because the High Court will defeat them. And Ron Caston had a particular experience, I think it was the Fijo case in Northern Territory, of where he tried to argue that native title would even survive freehold. You know, we know that the argument is that freehold title extinguishes native title, but he was trying to win a legal case to show the other way around. And he was saying this is not the time to go to the courts and fight against what we think is racism in the legislation. We're going to lose ground, and once you lose something in the High Court, there's pretty much no other place to go to change that legal opinion. So that's when myself and others, the West Australian Aboriginal Legal Service, a few other organisations, started going to the United Nations, and particularly to the treaty body, the third committee, the Committee on the Elimination of Racial Discrimination. Immediately they took this up as an urgent action, this legislation, and they called Australia to appear before it in the months ahead. And when Australia appeared before it and they asked the questions of Australia and were given the answers and so on, they made their findings that there were about 4 or 5 areas in this legislation, the Native Title Act, which is racially discriminatory. And those findings have stood the test of time. The third committee has, I think, on 3 more occasions since then, declared that the laws of native title in Australia are discriminatory. The parliaments had their own debate. A parliamentary committee took up the question, and because it was dominated by Howard government members on there, they said that committee is wrong, it's not discriminatory, but a dissenting report was produced by the other members on the committee who said it is discriminatory. So it created quite a big friction during those years of 1998, I'm just trying to get the dates right, 1998 through until 2004, 2005, about Australia's racism. And this, you will notice from those dates, also ties in very strongly with the demise of ATSIC, because ATSIC was one of the bodies that was taking this issue up at the United Nations, appearing at the United Nations, protesting and fighting on these sort of issues, and consistently being warned by the minister, if they continue with that sort of behaviour, something will happen to them. I'm not going to go into the history of what happened to ATSIC or how it happened, but simply to say that lo and behold, what was the social contract? Where is it? What happened to it? Because none of the things that had been building up through that time that I mentioned, through those actions and those things that I had mentioned, were applying. Even going back to something like that Aboriginal people have the right to determine their community's needs and to run programs and services to fund those needs has gone. The organisations now that receive funding from the Commonwealth Government are basically committed to contract to act as agents of the government. And the government of the day, the one that we deal with today, has the view that any of the funding that's provided through those organisations is Commonwealth funding. And anything that's purchased from that becomes Commonwealth purchases in the whole process. So that social contract has gone. That was so important back in the early 1970s to the way they operate. And that's just one example. And when you look at those examples that I look to, this is the change that's occurred through that process. Now, let me switch to Indigenous peoples at the UN. Now, you've obviously had a chance to look at a number of slides there. Some like this one you'll see inside the UN rooms and the meetings and so on. Some you'll see outside of that. So there's been the ones outside the room is caucusing. Indigenous peoples on a global level have been caucusing, working together, working out agendas, agreeing to strategies, and so on. And of course, the biggest thing we worked on, well, let me get this in an order. By 1993, the General Assembly of the United Nations had decided to recognise and act on the situation of Indigenous peoples around the world. And that's when it called the International Year of the World's Indigenous Peoples. And you may remember that in Australia, ATSIC promoted it quite well. But that was the first move then from the General Assembly to start a global attention to the situation of Indigenous peoples. The next year, it agreed in a resolution of the General Assembly to call a decade, an international decade of the world's Indigenous peoples, from 1995 to 2004. And part of calling that decade was to create a program of actions for states and for the United Nations to implement, to improve the situation of Indigenous peoples around the world, particularly to ensure that their human rights and interests are protected. However, and I'm jumping that 10-year time span to say by the end of that decade, not much had been achieved and not much of the actions had been paid attention to. So the United Nations immediately declared a second decade of the world's Indigenous peoples. One of the motivations was that there had not been concluded a declaration on the rights of Indigenous peoples. That was supposed to be concluded during the first decade. So they extended a second decade, and they called in particular in their resolution for the Declaration on the Rights of Indigenous Peoples to be completed, to be ready for adoption by the General Assembly. So another 10 years was created from 2005 to 2014, the key date, 2014. And fortunately, within the first couple of years of that second decade, the Declaration on the Rights of Indigenous Peoples was adopted in 2007. So 2 months after that resolution, 2 years after that resolution, the states finally got the hurry on, and the declaration was concluded. Now, it wasn't so easy as that. Just saying that, it wasn't such an easy process, because it required a lot of pressure going upon the states, a lot of agitation coming from Indigenous peoples, going to UN meetings, pushing for more floor time and more recognition at the microphone in these discussions and so on. And this is where the strength of Indigenous peoples at the UN basically has formed, because working in caucus, working in unison has meant basically everyone was pushing in the same direction for the same benefit. And it also meant that the Indigenous peoples were moving into other areas. It wasn't just the declaration, it was other parts of operations inside the UN. I'll come back to some of that. But it was also in other parts of international governance, agencies like World Health Organization, International Labour Organization, World Intellectual Property Organization, Convention on the Biological Diversity, etc., etc. So Indigenous peoples were discovering what goes on with these bodies and the utility of these bodies, and then following the same tactics in terms of being able to put the pressure down to say, why are we being treated in a racially discriminatory way? So back at the United Nations, a few key things happened during that post-millennium period, that 2000, so on. In the year 2000, in the United Nations, led by Secretary General Kofi Annan, became this big push to say that the human rights agenda of the United Nations is too weak. It's being overlooked, it's being ignored, and so on. So the Commission on Human Rights, which was the main body in the UN to deal with human rights, was replaced by a new body called the Human Rights Council. Now, it took a number of years for that to happen, and it wasn't until 2006 that the new Human Rights Council was formed. And the Human Rights Council was elevated to become equal to the other treaty bodies, charter bodies of the UN. That is the Security Council, Trusteeship Council, Economic and Social Council, and the Human Rights Council. And as Kofi Annan described it and was accepted, it's one of the three pillars of the United Nations. The pillars are security, which is the Security Council, development, which is ECOSOC, and human rights. And it was basically saying all decisions of the United Nations should not just be made in one of those chambers, it should be made as a joint action involving all three chambers. So any development, any security has to be developed with human rights. And a big part of that argument was the genocide at Rwanda. Everyone was saying, why did the United Nations let genocide happen in this modern world, and so on. So that's been pretty much a uniform commitment that has happened in the UN roughly in the last decade. And that happened at the same time that the Declaration on the Rights of Indigenous Peoples went through. The Human Rights Council was formed in 2006. It had its first session in June 2006, and the second resolution was to adopt the Declaration on the Rights of Indigenous Peoples. And then that was set up to the General Assembly, also to be adopted by the General Assembly. The Human Rights Council also reviewed the structures that it has for looking at the rights of Indigenous peoples, and created a new body called the Expert Mechanism on the Rights of Indigenous Peoples. And while it's not a requirement, it has sought to appoint to the 5 experts that sit on that body, Indigenous peoples onto that expert body. So Indigenous peoples were getting appointment onto the United Nations body. It was also happening elsewhere in the UN, in New York, where the Economic and Social Council created the Permanent Forum on Indigenous Issues. It actually created a little bit earlier in 2002. And that body meets for every 2 weeks. It has 16 representatives that sit on there. 8 of those representatives are appointed by states, and 8 of those representatives are nominated by Indigenous peoples and appointed by the President of ECOSOC. So these revolutionary bodies that were created see Indigenous peoples not only coming and attending at the United Nations, but now sitting on bodies which are specifically created to deal with the issues of it. The MRIP advises the Human Rights Council, and the Permanent Forum on Indigenous Issues advises the Economic and Social Council. And while I'm mentioning these structures, there's one other important structure that was created in 2002, and that was the creation of a special rapporteur on the rights of Indigenous peoples. It had a longer title then, but it's come down now on the rights of Indigenous peoples. And that position is probably the most important because the special rapporteur, who's been appointed by the Human Rights Council, has a mandate to investigate human rights complaints. The other bodies that I mentioned cannot investigate human rights complaints. They can provide recommendations on implementing the rights of Indigenous peoples, but they can't investigate treatment of Indigenous peoples in Argentina or treatment of Indigenous peoples in Kenya. As such, they do visits to these areas, they do comment, but the comments they make generally have to be general comments. They can't be criticisms of the government, they can't be findings of fault by the government. But the Special Rapporteur can. We've had 2 visits to Australia by the Jim Anaya, who was the Special Rapporteur on Indigenous peoples up until early this year, till end of April this year. And Jim Anaya has produced reports on Australia, including on the Northern Territory intervention, on extractive industries, and so on. So that position, that mechanism, as we call it, or special mechanism, has got a bit of teeth to it in that it can make findings about states, it can make complaints. Again, though, in the world of international diplomacy, care has to be taken. If the Special Rapporteur becomes unpopular, there can be a movement built up amongst the states to try and oust this person and put somebody else in there. But the rapporteurs we've had in place now, up until now, have been very, very good and expert at what they're doing. And the 3rd appointment has just happened. We've had 2 special rapporteurs now, each for 6 years each. Vicky Towley-Corpus started from May, and I would not be the least bit surprised if Vicky Towley-Corpus doesn't come to Australia at some point in the near future. And I'm sure that Congress will be the body that will extend an invitation to her at an appropriate time for an appropriate purpose. But that's jumping ahead of ourselves a little bit on that. So we have at the UN over this period of time, since 1982 essentially, right up till now to 2014, these mechanisms and these developments. So the mechanisms I've talked about, the UN Special Rapporteur on the Rights of Indigenous Peoples, the Expert Mechanism on the Rights of Indigenous Peoples, the Permanent Forum on Indigenous Issues, and these, you can call them mechanisms, the Declaration on the Rights of Indigenous Peoples. It's a standard, but it's also something that's a process. The International Year of the World's Indigenous Peoples, the International Decade of the World's Indigenous Peoples, the Second International Decade of the World's Indigenous Peoples. So there's so much work that's happened in the UN since 1982, but really these mechanisms I referred to have all happened in the period since 2002. I think besides the international decades, but the others have all come into place in the last 12 years. So here's a great strength, the body that's going on. Yes, I'd like to break. It'll give everyone a bit of a break there. I can talk. We just want to do a presentation before it gets too late as well. So this has been a massive build-up in the UN system of Indigenous peoples and Indigenous peoples' participation. And guess what? More is going on. The Secretary-General has presented a report to the General Assembly which is talking about the status of Indigenous peoples, saying that a lot of Indigenous peoples are in their own right nations, a lot of Indigenous peoples have governing bodies and institutions and so on, and should not be participating in the UN as civil society or as non-government organisations, but should be participating as governments and nations in their own right. And this report that the Secretary-General has provided is being examined by the General Assembly, and when I get on to the World Conference coming up, is likely to be further examined about a different status. It won't be the same as equal to the member states, because we won't be recognised as member states or as states in our own right, but we will be respected, hopefully, in the immediate time ahead as being of a different level than civil society. So these things continue to work on, and great inroads. But despite these great inroads, and when we get to question time you might want to talk more about that, I'll move now on to what's gone on with the states. So despite these great inroads, nothing much has happened in the states, apart from in the first decade, really none of the actions were implemented. It was a very poor outcome, which is why they appointed the second decade. Also, the second decade, which is only just completing now, this is the last year of the second decade, all the reports and the evidence is showing that the actions have not been put into place. The adoption of the declaration was one specific action which has succeeded, but other actions have not succeeded. In that situation, states have not really been as motivated and proactive as Indigenous peoples would have liked in terms of meeting the rights. And of course, we can immediately translate that back to Australia, going back to that period that I gave you a rundown on before, that timeline of where since 1996 we have essentially been receding from the social contract, and now in 2014 in Australia, I don't think we can talk about any social contract. There is no baseline on which government is operating to deal with the situation of Aboriginal and Torres Strait Islander people. So the World Conference on Indigenous Peoples is going to happen in, I've been counting the months, but roughly about 6 weeks' time, if I've got it right. 5 weeks' time, good. Exact timing. 22nd and 23rd of September. It happens, well, I should explain first off, it's called a World Conference, but it's not an open forum where would you go in and sign the right papers and walk into it. It's actually a session of the General Assembly. So it's a United Nations General Assembly session convened by states. It's what they call a high-level plenary movement, is it? HLPM? Yep. Meeting, sorry, high-level plenary meeting. But as Indigenous peoples, of course, we have been our usual audacious selves, and starting earlier last year, we have talked about, well, how do we crash this party? How do we get into a high-level General Assembly session and adopt our motto? I think it's becoming a wider motto here in Australia and worldwide. Nothing about us without us. Simple words, nothing about us without us. It's for the Australian government, it's also for the United Nations. So Indigenous peoples have been working in a very organised way, methodical way to prepare for this World Conference. In Australia here, the Congress, the National Congress of Australia's People, and the New South Wales Aboriginal Land Council colluded with each other to convene a session in Sydney at the NCIE of the Pacific Regional Indigenous Peoples. And we invited people from the region to come to that meeting, and from that meeting, with all the discussions and highlighting what are the important themes and issues for us, we concluded an outcome document from the Pacific. And we also talked about how we would choose delegates to go to the World Conference in 2014. We identified how we would select, how regions would be represented or sub-regions would be represented, etc. And lists of names were drawn up and so on. And there's a few people in the room here who were at the time, and also then continued on to attend that meeting that was held in Norway in June of 2013 of 400 Indigenous peoples from around the world to talk about preparation for the World Conference. Unfortunately, none of the slides that are coming up here are coming from that meeting. I didn't dig them out, but it was pretty fantastic. At the time, we had so many flags of Indigenous peoples around. We had so many cultural displays of Indigenous peoples around. We had a very, very hard-working team of draftsmen working on the documents for Indigenous peoples for the Pacific region, Mick Dodson and Mililani Trask, both of whom had served as rapporteurs on the Permanent Forum of Indigenous Issues, and both being very skilled in writing official reports and so on. So it was a fantastic occasion, a powerful occasion, and an outcome document came out called It was at the time called the Alta Document or the Alta Declaration. It was the Indigenous Peoples statement that they wanted to have adopted by the General Assembly at the World Conference. We said, this is what we want the General Assembly to adopt. It went to the, was it the expert mechanism that adopted as a UN document? Or was it the permanent form? Expert mechanism, I think. So during the expert mechanism meeting soon after that, this document was then adopted by the expert mechanism and given a UN number, a symbol, so it becomes a UN document. In fact, it might have been the Human Rights Council that formally adopted it in September 2013. So it is now an official UN document as well. However, when it's come to negotiations with the UN headquarters in New York about Indigenous peoples' proposal for what the outcome document of this conference would be, states put the brakes on and said, oh, this is a states-only process. Indigenous peoples not allowed. And so what ensued then for a number of months of going backwards and forwards is, actually, this is going back from 2012, so there's one more year involved in there, but was a negotiation about whether Indigenous peoples could participate in this World Conference, and if so, how Indigenous peoples would participate in this World Conference. So, and I'll jump a few things that happened here. A previous president of the General Assembly agreed to appoint 2 facilitators. The facilitators are essentially the coordinators, organisers and authorities for the World Conference, and normally it's a state ambassador that's appointed as a facilitator. However, on this occasion, they appointed the ambassador from Mexico, Ambassador Luis de Alba, and also John Henriksen from the Sami people of Norway. He was the nominee that Indigenous peoples put forward. So he appointed 2 facilitators, one from Indigenous peoples, one from states. This was new. This was a precedent in the UN General Assembly. What went wrong, though, is a year later when the new president came on, the new president wouldn't appoint an Indigenous person as a co-facilitator. So with lots of wrangling and don't give in and fighting going on, the final agreement that was reached was that the president himself, the current president, Ambassador John Ash, who's the ambassador from Jamaica, agreed that he would be the key person, the facilitator, but he will agree to 2 advisors coming from Indigenous peoples and 2 advisors coming from states. And this would create the balance of equal participation, that he would be informed by the 2 advisors. So that became accepted and adopted by Indigenous peoples in these negotiations, and is now the arrangements that are in place to prepare for the UN. So I am one of those 2 advisors, and I've been in New York since July to fight for the arrangements at the World Conference. The fight has been over the drafting of the outcome document. Remember I said that the Alta document was what Indigenous peoples wanted, but the states insisted on a document to be drafted and so on. On your tables you will see the draft of that document, which is it's called the first draft, but it's actually the second version of the draft, which was just released on Friday. So this is hot off the press. And if you look through it, look at it very carefully, because I would predict that not much of that draft is going to change before it's finally adopted by the General Assembly. We have the next round of consultations happening with states and Indigenous peoples representatives on the 18th and 19th of August. So when I fly back to New York, I'll land on the weekend and we'll go straight into those consultations. And I let you know that, as advisors, we're not tokens. I actually chair those meetings. So between the advisors, the 4 of us, we take turns chairing those meetings and conducting those consultations. And then we sit down and are involved in the drafting of the next version and so on. So the draft you're looking at there, you can very strongly accept that Les Melzer's pen has been on there. And the things I push for I've been mostly successful on. So it's the ability of Indigenous peoples to affect this process has been strong. In terms of my work on the draft, I'm in touch basically daily with the global coordinating group of Indigenous peoples who are now based in New York also. And of course that consists of representatives from each of the regions. Just to connect here for the Pacific region, Ghazali Orello is our representative there for that. Ghazali and I are quite close and meet quite often on the whole thing. So the document you have in front of you becomes the key focus for the World Conference. And if you take into account what I have been saying about the previous action plans and so on, there's a number of things about this document that we've adopted as principle. One is that we have tried to keep faith with the altered document. So many of the paragraphs originated from the altered document. That's the starting point. Is it time yet? No. The wording has changed, but the wording has changed to take into account comments that were coming from states. There were some states who were very heavily critical, very heavy against this, were saying things like the declaration is not a legally binding instrument and so on. So we've had to argue those things to get in better wording on this document.